Yes, supplementary. Is this a supplementary one? Okay. Appeal dismissed. Just a minute. Huh? It is here. That one. This also appeal dismissed. Huh? Okay. The other one.
The first one, the sentence will be reduced to the minimum.
Appeal dismissed, but sentence will be reduced. Yes.
First one.
My Lordship. Lordship, this is public interest litigation.
Implementation of the recruitment rule.
Yes, Lordship. That
You know, no fear lies against the service matters.
yes, Lordship, in public sector.
And moreover, the court cannot mandate the authorities to implement the law.
Lordship, that public sector regarding service method in public sector, that it can be entitled by through public interest litigation.
Where it is? Where is the law?
Lordship, this is just reservation of Arunachal.
Yes, I'm saying. Ultimately, you want that the recruitment rules which provides for 50%
Yes,
in the employment in the NIT,
Lordship.
it has to be implemented.
Lordship, actually, this has been implemented, but not especially not in this practiced by this NIT Arunachal Pradesh.
Ultimately, it comes under the service matter.
Yes, Lordship. But then it is reservation for Arunachal Pradesh, Lordship.
I understand.
Lordship, here is one case that Bhagwati versus DMS 1990 that the court may interfere where the fundamental right of public sector employed are infringed, Lordship. Public sector in this, Lordship. When this is generally for the Arunachal Pradesh, that it become the public sector, Lordship. That on that ground, Lordship, public service matter may be entailed through
See,
the PI.
reservation is a concession.
Yes, Lordship.
Reservation is a concession.
Lordship, may I go to the just fact for this establishment case, Lordship?
What?
Lordship, that Lordship, NIT is public import, national import.
We know. We're not saying that RIT PL doesn't lie against the NIT. We're saying what we're on is you sought to implement the service rules. It's falls under the service matters. So public interest litigation would not lie. If you are a qualified person, An eligible person, you may come by a writ petition.
Yes, Lordship, this is already implemented by Central Act. And
It's not been implemented yet.
Lordship, it is already implemented by Central,
It's okay.
but not by this particularly National Institute of Arunachal Pradesh.
So therefore, it's a matter of recruitment
Lordship.
and reserving 50% for the
Exactly.
indigenous people of the state.
Exactly, Lordship.
It falls under service matters.
Lordship. Lordship, that despite the service matter, it comes under the public sector, Lordship.
What does it mean?
Lordship,
Public sector, it falls, we're not saying writ doesn't lie. We're saying the public interest litigation
Lordship.
doesn't lie in service matters.
Lordship.
There may be cases where the service matter involves, but it has to have a different, the allegations.
Lordship, my crux of the case is, Lordship, despite this is service matter, Lordship, that reservation is,
Are you
So-
are you saying it is not a service matter?
Lordship, that exact crux is not identical to service matter, Lordship. Lordship,
What
this
is
is just-
what would be end result? Suppose if it is to be implemented
Lordship,
of the rules
Lordship.
in service matters only. Well,
That-
there is a recruitment rule.
Yes, Lordship,
You have to implement 50% reservation.
exactly. Lordship, my prayer is that
It's not a resolution.
You are a diploma holder. You may entitle, you may file a writ petition.
Lordship,
We'll
that I have
examine that, not public interest litigation.
Lordship, I have already submitted the representation also. Lordship, that fact is, Lordship,
See,
In-
your basic, the public interest litigation, according to prime facies, doesn't lie. So it's a question of representation. It's okay, it's up to them. You pursue with them.
Lordship, may I go to the just crux for this?
What cracks? We have read your petition. This is how many pages of petition? 19 page.
Yes,
So
Lordship.
I've read it last night.
How it is reservation for the.
Yes,
okay.
Lordship, that
Let us see the provision.
exactly, Lordship. Lordship, page number 28.
Yes.
Page number 28 is, Lordship, that as decided by Council of the Institute, as decided by the
Page
Council.
20.
28, Lordship. 28.
Yes.
Lordship, that 22, Lordship, section.
Hmm.
As decided by the council, the institute shall strive to recruit 50% faculty not domicile of the that state in which the institute is located. Lordship, meaning thereby already 50% is for the domicile, which is Arunachal Pradesh. Now NIT that without complying this, that only 15% has been given.
Now,
Lordship.
how it is reservation, sir? How it is reservation for
Lordship, that
the domicile?
yes,
Read it
Lordship.
again. Read it again.
That as decided by the council, the institute shall strive to recruit 50% faculty not domicile of the state in which the institute is located, Lordship. That only 50% will be recruited from the outside, Lordship. Now, this means 50% is for the domicile. This is not only in Arunachal Pradesh. There are 31 NITs, Lordship, in India, Lordship. That within this 31 institution, that 50% is this reserved for the domicile of the respective state, Lordship. And this also has to be applied in NIT also, Lordship.
Where it says 50% is reserved for domicile of the state of Arunachal.
Lordship, it is the 50% faculty not domicile of the, this is compulsion, that already 50% is Arunachali, Lordship, domicile, Lordship. Then when recruitment 50% faculty not domicile on the state in which the institute is located, Lordship.
So when we say 80% is reserved for APST, what does we mean?
Lordship, not, but like,
Let's say 80% is reserved for APST candidate. What does we mean?
Lordship, it is 50% for the
No,
You are trying to draw inference. You're trying to draw inference, positive inference from this clause.
Now, Lordship, that respective that NIT, this is mandatory that every this institution had reserved for 50% of the faculty is reserved for the domicile, Lordship.
Where it is?
Lordship, it's rule itself, Lordship.
Where is the rule?
Lordship,
Page 28.
yes, Lordship,
Rule 22.
22.
Yes.
That as decided by council, the institute shall strive to recruit 50% faculty, not domicile of the state in which the institute is located, Lordship.
They will strive. They may reach up to 50%.
Lordship, they already not more than 50%. They have already 81%, Lordship. They have recruited
85% from where?
from non-domicile, Lordship.
Huh?
Non-domicile. Lordship, phrase number, my paragraph level, this is mentioned that my paragraph 10 of page number 10, Lordship.
Let us see the reservation, where it provides 50% for domicile of the state, where the institute is located.
Lordship, that even if this reservation word does not come, but 50% it is mandatory for domicile, Lordship,
Where?
on
Where?
that context.
Where
Lordship, as per the rule itself.
where it is?
Lordship, just wish
22.
yes, Lordship.
Rule 22.
Yes, Lordship.
We don't agree. It says institutes shall strive to recruit 50% faculty not domicile from the state.
That
From
already
the state.
yes, Lordship. That already 50% is for domicile. But then 50% has to be recruited from the non-domicile, Lordship.
Where does it say?
Lordship, that as per
We'll just issue notice and we'll keep the maintainability open,
Lordship.
right? Heard Mr. G. Kato, learned counsel for the petitioner. By filing this petition, styled as public interest litigation, the petitioner has prayed for a direction to the respondent National Institute of Technology, Arunachal Pradesh, to reserve 50% of the faculty oblique post of National Institute of Technology, Arunachal Pradesh, for the domicile of the state as per the recruitment of NIT faculty rules, faculty recruitment, implementation of the NIT faculty recruitment rules, 2011. Having next para, consider the materials and the nature of the prayer made by the petitioner in this petition, where of the prima facie view that matter relates to service matters, according to us, which would not be maintainable, as it is the settled position of law that no public interest litigation lies in the service matters. Next one. However, we deem it appropriate to issue notice, simple notice at this stage, just of keeping the maintainability of the present public interest litigation open. Next, accordingly, issue notice. How many respondents returned?
3 respondents.
4 weeks. The consent with the petition shall take a step for service of notice upon respondents. All the respondents by registered post with the AD within 3 days. List accordingly.
Like,
May I please, Your Lordship? Item number 3 is application for suspension of sentence. Since it's coming up for the first time,
Will issue notice.
yes,
Yes, heard MS and Duncan plan consent with the applicant. By this is an application under section 389
yes,
CRPC 1973 for praying for suspension of the sentence dated 03/05/2023 and section 302 IPC and sentence for imprisonment sentence dated 03/05/2023 sentence convicting and sentencing the accused
life imprisonment,
huh?
to life imprisonment.
to like for life imprisonment
Along with fine of rupees
and
10,000.
the fine of rupees 10,000 in default the payment of fine the convict is to undergo for the simple imprisonment 3 months in connected criminal appeal
Yes. Sorry.
within bracket 22 of 2022 issue notice returnable by 4 weeks. MS L. Hage, learned additional PP, appears on behalf of the state. Next para, the learned counsel to the applicant to take stage for service of notice upon response number 2. By registered post AD with AD within 3 days. This up to 4 weeks.
Your Lordship, may I mention just there's one matter which has been transferred from the Supreme Court, and it has been listed here in the High Court. But then the concerned court, who is in the Supreme Court, he is not aware of that. So he wanted to have a date. So may I pray that date may be fixed, especially for the PIL 8
We'll see on
15.
15.
15.
Yes. May your lordship indulges for moving an unlisted motion. It was filed on Saturday because of.
You are not on the holiday mood. Are you not on holiday?
I am.
Then what is the urgency?
Urgency in the sense, not much actually.
We'll see.
That was filed on Saturday because of the court. It has now been filed.
We'll see.
May it please your lordship. I am praying for moving a motion urgent today, my lord.
What is the
Urgency is
urgency?
that on 26th, my lord.
Yes. 26.
On 26th, my lord, court passed interim order. In spite of interim order, they have issued a fresh NIT, my lord.
Huh?
On 26th of June, my lord, this honorable court passed an interim order restricting them from issuing NIT, my lord. On 27th, they have issued the NIT, my lord. I am challenging the NIT.
We'll see.
May I please, Lordship? Lordship, I beg to mention one urgent WPC. Lordship, in this regard, the Honorable Court has already given judgment not to issue tender, but despite of the order by this Honorable Court, the respondent authority has issued.
We'll see. If we find that there's no urgency, we'll impose a cost.
It's very urgent, Lordship.
If it's not urgent, if we find that if it's not urgent, then we'll impose a cost.
Lordship.
May I please, Lordship?
Yes.
Lordship, I may be allowed to move one unlisted CRP today. Because there
What
is
is the urgency?
urgency, Lordship. What happened? There is a execution proceeding
We cannot
Which-
state your execution.
No, Lordship. The execution proceeding has been initiated against the present petitioners who are not party in the original decree.
Very
But
straight.
next,
We'll see.
yes, next date is on 9. So Lordship, and along with one contempt application for notice only.
May I please, your lordship? May I please, your lordship? My lord, one regular bail application, can I make mention?
Regular?
My lord.
Okay, we'll listen. Notes.
Okay. My lord, I beg to mention one criminal appeal for unlisted,
Single bench matter.
single bench matter,
New filing.
already filed. my lord.
We'll see.
May I please? Your lordship, I beg to mention item 2 for withdrawal, your lordship.
Why?
Your lordship, there are some vital document which has to be annexed, but in
But
advantage.
fresh.
Yes, your lordship, with the liberty.
Mr.
IBAM, your lordship.
Item 2.
Yes, your lordship.
IBAM, learned counsel for the petitioner, submits that he may be allowed to withdraw this writ petition with a liberty to file a fresh list of next para. Prayer is accepted. List of next para. Accordingly, writ petition stands disposed of on withdrawal with a liberty as prayed for.
Highly ordered.
May I please?
Yes.
In this case, my lord, we both, private respondent number 6 and me, we both are LOT. We both are having government land allotment respectively. And there was a dispute.
Where is the impugn order?
Is it page 32, my lord?
32.
32, my lord.
Yes. Read it.
Type copy is at page 33, my lord. Both the parties, namely Sri Tasap Kyalu, private respondent number 6, and Sri Tarak Siga appeared in the office of the undersigned on 24/5/2024 as per the summon issued by number so and so dated 20 May 2024 regarding alleged unauthorized encroachment of the allotted plot of Sri Tasap Kyalu at plot number 6 located at Ganga Market, Daporejo. Heard both the parties and gone through all the documentary evidences produced by the parties, perused all the documents, cadastral maps, photographs available on record. The field verification report submitted by the land management staff of DC office has clearly mentioned that Sri Tatak Siga has encroached upon an area measuring 8 square meters, 2 meter into 4 meter of Sri Tasap Kyalu by constructing a septic tank. On perusal of all the evidences available on record and submission of both the parties, it is found that the septic tank constructed by Sri Tatak Siga lies within the allotted land of Sri Tasap Kyalu in plot number 6. Hence, the undersigned is inclined to direct Sri Tatak Siga to initiate action for removal of the said encroached structure immediately in order to allow taking up the activity in the said land by Sri Tasap Kyalu.
It's okay. What's the wrong? On factual verification, you found to be encroached 8 square meters.
And on
You
factual,
removed it.
and on factual verification of the same land, my lord, there is a order of deputy commissioner,
To
Kindly-
maintain the status quo.
my lord.
What does it mean? That is that point of time.
Because, my lord, we have to
Now
understand.
finally you have agreed to you have submitted to the decision
My lord,
for settlement, and you have produced the records, and there's a verification by the office,
no, my lord.
and it's found
Yes,
to be
because-
you are encroached.
In a perspective, my lord, as per Land Revenue and Settlement Act, the deputy commissioner is the revenue official. If anything has to be done, because both are LOT, both are government land LOT. And how do this state official,
No, that's the reason you have not protested. You have submitted to the settlement.
therefore, my lord, there is a
Just
provision of,
because it is not against you or it's not palatable to you, therefore you are raising this issue.
My lord.
Why you have not raised it this when this order was passed?
my lord, be that as it may, my lord. But then we have challenged this order. There is a appellate court of deputy commissioner. Any order passed by the state officer that can be appealed before the deputy commissioner.
This is under what? Under what
Under
provision he has
Arunachal
passed?
Pradesh Eviction of Unauthorized Act 2003, my lord.
And then what section?
Uh, section,
All the appeals are not
Three.
appealable, all the orders are not appealable. It's under section 3. Is it appealable before the DC?
yes,
Let us
my
see.
lord. Ordinance on Fridays. Unauthorized, volume 7.
Where is your
Appeal
appeal?
is provided in section 12.
Yes, that's what I'm saying. Every orders are not appealable. A particular orders only.
My lord, all the order of state official.
Well, let us read.
Page. I didn't bring that one. I thought my lord would be understanding that. Section 12.
Let us see.
Appeal is my lord, my statutory right at least, my lord.
If it is,
My lord.
if it lies,
Section 12, my lord.
is it Land Settlement Act or Eviction Act?
Eviction Act, my lord.
It's not here. Next volume. 8. This order is passed under what section? Which section?
Section 7, my lord.
How do you know? From where you get it?
That is not mentioned in my this thing, my lord. But then I have mentioned under the provision, since there is a appellate court, so page 35 annexure 11 is my appeal, my lord.
You have filed the appeal on 24th of June.
24th of June, my lord.
Wait
Now
for-
the difficulties is that
It's
that is
too
at page
early.
35. Difficulties is that, my lord, the incumbent deputy commissioner immediately after the election, that I have mentioned in paragraph 7, my lord. Paragraph
What?
7.
What?
But immediately after election, the incumbent deputy commissioner, he left Daporizio, my lord. Kindly come to paragraph 7, my lord. Page 8, my lord.
Yes.
That the petitioner begs to state that being highly aggrieved of such an arbitrary impugn order dated 26/2024 passed by the ADC cum state official Daporizio, he prepared an appeal to the Deputy Commissioner Daporizio by submitting written appeal petition dated 24/6/2024. However, the incumbent Deputy Commissioner Daporizio, namely Sri So and so, has left Daporizio immediately after the election, citing the reason that he has to look after the construction of highway road in the capital complex. And the ADC cum state officer Daporizio is presently taking in charge to the post of Deputy Commissioner Daporizio. When the appeal was presented by the petitioner, the ADC cum state officer Daporizio scolded the petitioner and told him to remove the septic tank immediately, or else a coercive action would be initiated against the petitioner. Thus, having no other option, your humble petitioner is approaching before this honorable court with a limited prayer to suspend the impugn order dated 26/2024, pending appeal of the petitioner before the Deputy Commissioner Daporizio for the ends of justice.
When is coming back?
This, my lord, may kindly. I have obtained it from somewhere in the WhatsApp group. Immediately after election, he do not want to be continued here at Daporizio. The incumbent deputy commissioner, he do not want to be there at Daporizio. And he left the station. However, his leave was accepted, my lord, for 4 days. There is an order. Under these peculiar circumstances, my lord. At least pending appeal, my lord.
Is it the case that the present incumbent deputy commissioner has to take up this appeal?
My lord,
No other
As
deputy
per the
commissioner. No other deputy commissioner.
other deputy commissioner can be, my lord, but then kindly see the next order, my lord. The state officer himself is holding the post of deputy commissioner now.
Yes.
Someone could have waited for some time. This is 24 June only. It's too early. Just 1 week only. And then also, can we see from the verification order, this the final order that, he had enforced, and then in his petition itself in the allotment order, though he's an LOP person, admittedly, in the serial number 11, person, in the allotment order,
Yes.
page 15, starting from page 15, this is type of,
Page 15. 1-5.
yes, this is his allotment order. In the allotment order itself is in page serial 11, it is written LOP should refrain from any act of encroachment to adjacent area. So we have encroached the adjacent area.
No, factually,
I
he
have not
doesn't have any case, but the problem is
Yes,
deputy
Yes.
ADC who has
Appellate
passed this order.
He
is not
cannot.
holding the thing, and then in the meantime, according to him, he made a statement that the ADC has scolded him.
for filing appeal, my lord. At least, my lord, under these peculiar circumstances, at least, my lord, till the first instance of taking up of that appeal by the deputy commissioner, this order may be kindly suspended. my lord.
in my submission that this is 1 week only. That this he might come back, Lordship, in 2-3 days also.
If he comes back, then definitely that will be placed before him only. But in the meantime, if some coercive action taken, my lord, I'll be highly prejudiced.
Privacy, you have encroached.
No, my lord. The same septic tank, my lord,
And
may
you have
kindly
disposed it of. You take up, as in when you till then, you'll just let them maintain status quo.
Lordship.
All right. Heard Mr. K. Tama, learned counsel for the petition. We're disposing of,
my lord.
and also heard MSG at the learned additional senior government advocate
Lordship for 1, 2, 3, 4, and 5.
appearing on behalf of respondent number 3, 4, and 5. Again, there is the private respondent is
Private
there.
respondent is there.
My lord.
Lordship. Who is claiming this portion of the land, Lordship? Where he have
This is
encroached.
the difficulty again.
Even if there is any order passed, my lord,
Yes, Lordship.
that will be affected till only the first instant when this appeal will be taken up by the deputy commissioner. It is not going to prejudice the private respondent number 6 in any manner, to my humble understanding.
Tomorrow they will come and say the court has violated the cardinal principle of natural justice.
Oh, my lord.
Yes. so
The
we
first
don't-
instant when deputy commissioner takes up the matter.
Anyway, next way. Considering the nature of the issue involved with this petition, the present petition is taken up for disposal at the motion stage. Next para. The petitioner being agreed of the where is the impute order?
At page 32, my lord.
impugn order dated page 32, number so and so dated 20/06/2024 has filed this writ petition. Passed by the ADC cum state officer, Upper Subansiri district. Whereby the petitioner
Impugn order in third para, Lordship can see here, it is found that the septic tank constructed by Sri Tadak Sigya lies within the allotted land of Sri Tasak Kyolo, who is the private
Ah.
respondent here.
whereby it is found that the petitioner has encroached 8 square meters of land, which belongs to the respondent number 6 by constructing a septic tank. And the petitioner is sought to be directed for removal of the said enclosed structure. They have filed this present petition, particularly on the ground that the deputy commissioner, who is the appellate authority, has already left the district, and the additional deputy commissioner, who has passed the impugn order, is holding the charge. Next one. Having considered that the petitioner has filed an appeal against the impugn order dated 22/06/2024 before the appellate authority, i.e. Deputy Commissioner, Upper Subansiri District, Dapur region. Which appears to be an statutory appeal under the provisions of the Arunachal Pradesh Public Premises within bracket eviction of unauthorized occupants, bracket clause Act 2003. And and also considering that the there is no appellate authority at present in the district to take up the appeal of the petitioner, without going into the merit of the impugn order as well as the claims of the parties, I deem it appropriate to close this writ petition with a direction to the appellate authority, i.e. Deputy Commissioner, Upper Subansiri District, to dispose of the matter. Dispose of the appeal of the, consider and dispose of the appeal of the petitioner within a period of 1 month from today. List of till the it is also provided that till the appellate authority takes up the appeal of the petitioner, no coercive action shall be passed against the coercive action shall be taken against the petitioner and the parties to maintain the status quo till the appeal is taken up by the appellate authority.
Suffice.
Not the disposal, when
Lordship.
till taking it up.
Madam. Highly obliged.
Obliged.
in first line, considering what is the first paragraph. Considering the nature of science, you just read that. Just read that. First paragraph. As this court considers that no prejudice will cause to the prime respondent for the simple reason that for the reason for no prejudice will cause to the private respondent in view of the proposed order within bracket infra within bracket close. Then is a represent state disposal. Withdrawn.
May I please, Lordship?
Yes.
Yes, Lordship. Lordship, in this case, the private respondent number 5 has plotted a tender dated 21/3/2024, calling the bidders for construction of multipurpose stadium for government high secondary school and secondary school at Koloriang, Kurungkume district.
Yes.
Lordship, the present petitioner being qualified for the above said tender work has participated in the said tender, and thereafter, Lordship, his bid has been selected as L1. Lordship, page number 26 of the writ petition. This is the minutes of bid opening summary of financial as well as technical bid.
Yes.
Lordship, here in serial number 1, that is MS Atuapa Enterprise, which is the firm of the petitioner, has been adjusted as L1, and his quoted amount is so and so. Thereafter,
It's L2.
L1.
Atuapa is
Sorry, AP Enterprise. AP, sorry.
Ah.
AP Enterprise is the
You
petitioner.
are AP Enterprise.
Lordship.
This is by Chera Yama.
Yes, he is the proprietor of AP Enterprise.
So
Thereafter, Lordship, after
the firm is not a party.
Lordship,
Why?
Lordship, I have made party.
Where it is? You have not participated as a Srimati Chera Yamang?
I have participated as MS AP Enterprise.
Yes, then AP Enterprise is not a writ petitioner here.
Lordship, Sierra Yama is represented. She is representation of the our
She
firm.
will be there. She will be a respondent number petitioner number 2.
She is the sole proprietor, Lordship.
It's all right.
She is the sole proprietor.
It's okay.
Thereafter, Lordship, on 22/5/2024.
Sir, where is the form? Form is not a party before the court.
Was title is wrong.
Lordship. Sorry, Lordship.
Form should be a petitioner.
Lordship.
Form is the bidder.
Lordship, form is the bidder.
Then why you have not made him
Lordship.
Form should be the petitioner and then the proprietor.
Lordship, since Chera Yama is the sole proprietor of.
Doesn't matter. Form will be represented by the proprietor only.
She is the sole proprietor. That's why I have filed in her name.
You filed an amended petition or file a fresh petition?
Lordship,
Who has participated? Who is the bidder?
it's MS AP Enterprise,
Yes.
represented by Chair
Is the petitioner, if you are agreed by the action of the respondent,
May I please, Lordship? Lordship, the same petition has been filed by the other petitioner, and in that case, this honorable court has stayed the impugned order. There also, it was represented by the sole proprietor.
if it is stayed, it's okay. You file it fresh.
Lordship.
Or Mr.
I'll make a
Itaba,
necessary
that
amendment.
consent for the amendment or
Yes,
unless you amend it, we cannot take it up. All right.
Lordship.
Mr. Itaba, learned counsel for the petitioner, submits that he has inadvertently omitted to make the form as a petitioner in this present writ petition. List of therefore, he pressed for withdrawal.
I'll make a necessary amendment, Lordship.
He pressed for a time to file an amendment petition. Mr. The prayer is allowed. List this matter after. After that means vacation, after vacation.
My lord,
List
both the
after 2
items,
weeks.
my lord, 4 and
Yes.
5, my lord, 3 and 4, sorry. Same defect,
Same-
3 and 4.
Same
also.
defect.
Oh.
Deep
Same order
coverage.
in next. We'll have to go by the basic procedure.
Lordship.
Just cannot allow like this.
Four is set.
Same order. Huh? Yeah, what is this?
Lordship, Government of Arunachal Pradesh has issued advertisement notice, Lordship, for the post of 65. And out of 65, there is 2 reservation for disabled person, Lordship. That for this disabled person categories of the hearing impair is not included, Lordship. Page number 26, Lordship. May I come to page number 26?
Page
Yes, Lordship.
26.
Yes, 26.
Yes.
Lordship, the category of disabled and reservation for PWBD vacancy for 1 post each under Director of Higher and Technical Education and DME Health and Family Welfare is only locomotor disabled, Lordship. Lordship, that petitioner, despite he lost his this hearing sense, but have graduated from the Lordship recognized university, Rajiv Gandhi University. And now qualification is diploma in computer. And at the same time, the petitioner possesses this qualification also, Lordship. And now in this advertisement, only locomotor is being given.
You want that hearing impaired should also be included.
Yes, Lordship.
How? Why?
Lordship, this is hearing also comes under the category of the PW person with disabled benchmark disabled, Lordship. And Lordship, his identity card is, Lordship, disabled identity, Lordship, page number 36, Lordship. Page 36, Lordship, 36.
What is this?
This is identity card for a person of disabled.
It's okay. We're not disputing.
Yes, Lordship.
Yes.
Your lordship, so far he's making submission, that is right, my lord. He also comes within this category, my lord,
Under the act.
under the rule, my lord. rule is here, my lord. My lord,
Then
might be, my brother has forgot to bring that. My lord, but here actually the rule says, 2008 rule says, 2018 rule says, my lord, under rule 15.7, my lord. Rule 14 says he is also within the this category of the this PW
disability.
my
Yes.
lord, disabled person, my lord.
Yes, then
15.7, your lordship, 15.7,
page, which one?
15, rule 15.7.
7, yes.
Yes. So may I read, my lord?
Yes, if the number of,
If the number of vacancies in a year is such as only to cover one block or two, discretion as to which category of the disabled should be accommodated first, based in the head of the establishment, who shall decide on the basis of the nature of the post, the level of representation of the specific disabled category in the concerned post,
Great
my lord.
post.
So this is, the post is of UDC, my lord. So from the bench, my lord, this roster, my lord, we have this first given preference to the OPD, my lord, orthopedically disabled person, my lord, by the virtue of this power, my lord. And in next time, my lord, others will also come, my lord. Only one post. It is only for our department, my lord. But the another contention raised by my brother that out of 65 there should be 3, 4. That I don't know, my lord. That part, how much should come? That they will clear, my lord. But regarding this, my lord, we
you
have,
have the discretion,
my lord, I have that description.
On considering the nature of the
Nature
post.
of the job, my lord.
Job.
And lordship that it is rule.
Okay, we'll issue notice.
Yeah. Lordship, there is
Heard Mr. G. Kato, learned counsel for the petitioner. Next para. Challenge made in this writ petition is to the advertisement dated 06/06/2024, where it is page
26 lordship.
page 25,
Yes.
issued by the
Arunachal Pradesh Staff Selection Board, lordship. Secretary of Arunachal Pradesh Staff Selection Board.
issued by the Arunachal Pradesh Staff Selection Board for filling up of
That lordship, UDC in UDC, lordship. Lordship, in Department of Director of Higher and Technology Education.
inviting application for combined graduate level examination, 2024 for recruitment to grade C post against the vacancies of the various departments, including yours. This is only your department or some other departments too?
Lordship, in also health and family, there is one reservation, but this is qualification is librarian certificate that petitioner does not have, lordship. Only in UDC, lordship.
You're concerned about this
Lordship, where I am eligible, lordship.
UDC,
Yes, lordship.
page 26.
Yes.
In all departments or only one department?
Only one department, rest department, lordship. I am not able because I have no certificate of the library.
Probably
Yes.
post of UDC in the department of what? In the Director of Health and Services.
Yes, lordship. Director of Director of
Higher,
Technical Education.
Director of Higher and Technical Education. Is it?
Yes, Lordship.
Technical Education and Health and Department.
No, Lordship. Director of Higher and Technical Education.
That's all,
Yes, Lordship.
not the health.
No, Lordship. For that, Lordship.
Under Director of Higher and Technical Education Department. No, Directorate of Higher and Technical Education, Government of Arunachal Pradesh. Whereby the category of disability and reservation of PWBD is given only for the locomotor disability. List of the Learned Counsel, the petition, next para, submits that
Thief person. Hearing impaired. Disabled with hearing impaired.
is a person with disability of hearing impaired. And is having the eligibility for recruitment to the post of UDC under the said department. In the said department for the category of disability. List of. He submits that there are 65
Lordship, 65 as per 65 post.
65 posts of UDC.
No, Lordship,
You-
this is different post, Lordship.
Okay. Then what is the basis of your claim? You tell us.
No, Lordship, that my challenge, Lordship, only for UDC, this category has to be included hearing impaired, Lordship, only, Lordship.
He submits that the category of hearing impaired has to be included in the reservation for PWBD vacancy of UDC, whereas the authorities have illegally indicated the category of disability and reservation for PWBD vacancy for locomotor disability only. List of. Next paragraph. Issue notice returnable by 3 weeks. Mr. Tijamo, Learned Standing Counsel,
My lord.
appears for Learned Standing Counsel Education Department, appears for
2 and 3, my lord.
enters appearance and accepts a notice on behalf of
2 and 3, my lord.
respondent number 2 and 3. And
I'm on behalf of Mr. S. Tapi, standing counsel.
MS K. Wang, Learned State Council, appears and accepted notice appearing for Mr. S. Tapi, then counsel for the APSSB, accept notice on behalf of respondent number 1. No formal notice. Since the since the respondents are represented by the learned counsel for the learned counsels, no formal notice needs to be served. However, extra copies so and so. That's all. We'll see.
Item number 3.
Where is the impugn order?
Impugn order is at page 111 and extra 11. Type copies at 112. Type copies at 112.
112.
112, yes.
You are 9.
My lord. By this, my lord, even our who have been restrained from discharging our function as contingent staff also. In terms of the relevant rules, contingent staff has been, my lord, made a source of recruitment, 50% in fact. Those who have completed 15 years of service. Now, by they themselves, my lord, violate the 2019 rules, my lord. Because there was a board constituted. They recommended the director, my lord. So very well, my lord, they have done it. We have put that to there's another thing, but due to the length of our service, my lord, in due course, we would have been qualified, my lord. And admittedly, we are senior, my lord. My lord, they protect us, my lord, my lord. As contingent only.
Are you challenging the cancellation of regularization order?
Yes, in another petition we have challenged. But that also, my lord, what the prayer would have been ultimately was, once all these people cross 15.
Is there any stay?
Yes.
There is a stay.
No, there is no stay. Regularization, there is no stay. Cancellation of regularization. But at least we should have reverted back to my lord contingent, my lord, because
See,
only the regularization was cancelled,
See, sir, it's very hard.
my lord.
Contingency.
But I would have understood, my lord,
It's not
but
an appointment order. Now your regulation.
regularization is gone, my lord. I understand
gone.
that. But my lord will see the recruitment rules, my lord, kindly see page 29. Since the recruitment rules provides contingent staff as a source.
It's okay. That is the matter to be decided in the petition with
My lord, that
where you have
will-
challenged.
that petition will become infructuous
Okay.
if I am not protected. So, spend 17.5. Because I will no longer be contingency also.
You can restate it.
But not that-
This court is of the view, since your basic, I mean, those contingency basis under which you were appointed, it's gone now on regulation. And now
That I
your
understand, my
regulation
lord.
has
But when
been,
the regularization is cancelled, I have understood that, my lord. The contingency is a temporary thing. But once the 309 rules, my lord, provides that platform, that a contingent staff who have completed 15 years, would, my lord,
no, that's what I'm saying. That is the matter to be determined in the writ petition.
no, my lord. There only the cancellation of regularization is under challenge.
Yes,
Because once, my
because
lord,
rules promise for regularization.
yeah.
Therefore, your service could not have been cancelled. I mean, regulation could not have been cancelled. That is your
No,
case.
no, my lord, but it was not done in a proper manner, my lord. The regularization has to be done by the APSSB.
How you were appointed on contingent basis?
Contingent, my lord, were just appointed, my lord.
That's the problem.
That is the difficult. But my lord,
I mean,
equity also, but apparently we were senior most, my lord.
it's
the
okay.
senior
That's
court,
what I'm saying.
yes.
Ultimately, all these issues are to be considered in the writ petition.
My lord will take this also along with the writ petition, my lord.
We'll fix along with that.
My lord will take,
But
my lord
we
will kindly
can-
protest us, at least as contingent staff, my lord. To
No,
some
I
extent, my lord,
No,
is
human
equitable
consi-
jurisdiction
no,
also.
in human
I understand,
consideration,
my
we
lord.
understand. But then,
But my lord will kindly consider, my lord is sitting in the equitable jurisdiction also. These persons are admittedly senior.
once you succeed,
Yes.
you'll be reinstated.
That might be difficult also, my lord. Because they're the only the cancellation.
How long you have to have after regularization?
Cancellation of regulation is under challenge.
Now, how long you have?
Thereafter, my lord, till the issuance of this order, we will functioning as contingent staff.
Hmm.
What I'm praying, my lord,
Yes.
since my lord, kindly consider, my lord, since your lordship is jurisdiction also. This were the senior most, my lord. The department ought to have sent it to the APSSB.
Hmm.
Apparently, we are the senior most. It is not my fault, my lord. Once, my lord, my services now are gone. Even the contingency I have been now been restrained since I was functioning in that manner.
No, this one thing, how you have been appointed on contingent basis for the purpose of interim. You show us how you are appointed.
Contingent, my lord, apparently, but it was not, nobody has
Just
put that
pick
under,
up.
nobody has put that under
That's,
challenge.
that's the
But
reason.
admittedly, my lord, we are the senior most. And apparently who are below us also have been appointed in that manner.
That we'll
that is
consider. We'll take along with this matter.
Then my lord will make some
Will-
observations so that there is a live issue, my lord, ultimately.
That will be man of subject to the outcome only. Ultimately, if they succeed, they will get everything.
But you have
My lord,
appointed,
kindly see.
just wait. You
My
have appointed them and then allowed them to continue and then maybe irregularly you have done it.
Malo, that is why, Malo, the illegality has been committed by the particular officer and against which, Malo, the case has been registered. Now, disciplinary proceeding, who person involved has been taken. Now, the moment it's come to the light of the authority that there's illegal.
No, it's just that it ought to have been through the public, step selection board.
Yes.
Malo,
Not
this,
that they are not eligible.
yes, Malo.
And
This should have
it's
been
not
through,
that they could not have been considered for regularization.
Malo.
That is the
Isn't it?
thing. That is the thing, my
They
lord.
could have been
Yes.
considered for, because rules permits.
Yes.
Malo, that
It's the only recruiting agency.
Yes.
Malo,
You have bypassed the board, which supposed to recruit them or regularize them.
Malo, in the
And
If it
admittedly,
rules
they are the
permits-
senior most. There's no
Yeah,
dispute on that.
Malo, regularization process is concerned, but the regulation process, there has to be a committee, Malo. Committee headed by the head of department, Malo.
No, no.
In consultation with the staff selection board, Malo.
There
Now,
has to be a limited departmental
now
examination.
that is what, Malo. That part has not been done, and having found the illegality, Malo, the large scale, it's
It's
not only
okay,
case.
it's okay, but then you are that of manpower. Why don't you allow to continue till?
Malo, that
till
is
they
why,
make
how
a
come this
decide?
has, there's no the short of the manpower as such, Malo, even rather there's a,
Excess.
yes, Malo, not excess, Malo, there's
No, no, my
a
lord.
drainage of the state exchequer. That is why, how this fact come to
No,
light.
no,
Malo.
will not decide
Malo.
those matters today. Will not look into those matters
Malo.
today. What whereon is, since you have appointed them on contingent basis before the regularization and you
Malo.
have used them, employed them, why don't they be allowed to continue on
Malo.
contingent basis?
As of now, Malo, they were illegally regularized in year 2019. Now, after 4 years, Malo, as of now, we cannot say the sanction force, because the even contingency sanction force has to be there, Malo. Now, in this case, Malo, even impugn order, the challenge impugn order is, Malo, is in respect of cancellation of its regularization order, Malo.
No, it's okay. That
Now-
is another issue. That is another in the writ petition.
My lord, my lord.
What about this? What they are saying is
My lord,
your,
that is
their cancellation is the cancellation is in respect of regularization.
my lord, right.
That their basic appointment as a contingent staff, why should be
My lord,
why they should not be allowed to perform?
contingent staff, if it is sanctioned posts there, exists, it cannot be left vacant.
That is
for
something
long
you have to
period.
get instruction
that
first,
is
you know,
what,
something
Malad,
like that on the
As
first.
of now, my lord, if really if it's there,
They
Malad,
were allowed to
no, my lord. They
work.
have been illegally, they have been discharging. That's why this order, despite of the order, first, on 25th August, Malad, the order was passed by the commissioner level, Malad. Your appointment was done illegal, therefore cancelling and directing the deputy
Not
commissioner.
appointment, regularization.
Yes. Now, deputy commissioner,
What was the appointment orders? As a
Appointment
contingent
orders.
staff?
As contingent,
Let us see,
starts from page 33.
33.
My lord will see that they cannot just
Allah.
say these things just now like this. Initially, my lord, they have been using their service like this. Initial appointments were only for 89 days. They continue us for years and years. This is the manner in which appointments were done. Initially for a period of 89 days, then they continue to use us. My lord, no, that recently this Uma Devi judgment also has been, my lord, distinguished also recently. How can they do this? And it is not our fault.
2009.
2009, petitioner number 2 is 2008.
Then
Others are, my lord, I will just point out the dates. P1 is 37, 2009. P2 is 16/6/2008, P3 is 7/8/2009, P4 11/8/2009, P5 19/9/2009. All these are always now in fact on the verge of, my lord, being qualified. P2 has already qualified.
All 2009 and 8.
Yes.
8 and 9.
Yes, petitioner 6 and 7 are 10 and 12. They are a bit left.
No, 8, 2009 to 2010.
Yes.
So what is your, are you saying these they were appointed in, they were not in the sanction force?
My lord, absolutely, my lord.
From where?
My lord, here, my lord, they have been now, my lord, the
No, no,
challenge.
no.
Now, how we can say that, my lord, the 4 years, my lord, that we cannot, my lord, presume it, my lord. Now they have been paid salary till their release, my lord. They were paid up to 6 September, my lord.
September of
September 2023, my lord.
23.
Thereafter, my lord, thereafter, my lord,
That was as a regular employee in terms of the
regular employees, my lord, you see this. When there should be a specific order, my lord, from the authority that they are allowed to continue as it is in the original post, my lord. When once regularized, my lord, the post, my lord, it's gone, my lord. And after serving 4 years back, how can claim that the post already left, my lord? An impugn order challenging it is against the cancellation regulation order only.
No, that's what I'm saying. That's what I'm saying. What his case is in this petition is
My lord.
regulation that is pending with it is
My lord.
case issue to be determined in the writ petition.
Yes, my lord,
Whether it is correctly cancelled or
my lord, in
legally cancelled or not, that will determine. But here is a case. What petitioner is saying is that
my lord,
their regulation has been cancelled, not the contingent appointment, and they have been serving since more than 10 years.
my lord, the presumption will not do. My lord, in their
Even department more than 15 years.
itself, my lord, never prayed for. They have not prayed for continuation in contingent staff. They have prayed for cancellation of the quashing of the impugn order, my lord, terminating their regulation, my lord.
No.
My lord, their prayer itself, my lord, see.
My lord will see the 17/5 order at 111.
17.5, my lord, will see at page, I'll just clarify, my lord, that's why, my lord. 12, page 12, my lord, will see the impugn order type copy. In pursuance of commission order, my lord, page 1112, my lord. In pursuance of commission education.
Page
1112, type copy, 1112, it's impugn order, my lord.
yes.
Now, in pursuance of commission education, government of Arunachal Pradesh wide order dated so 25th August 2020. This is the termination order passed by the commission, my lord. Now, these impugn orders in the line of this order, in compliance with this order only, despite of the order passed by the commission, they were unauthorizedly continuing the service. That's why this order has been passed, my lord.
My lord will kindly have page 113. After our regulation was cancelled, we will continue to discharge our duties. And thereafter, when we serve this legal notice for payment of our salaries as contingent staff at page 100, thereafter this order has been passed. My lord will see the last paragraph 113. Hence, the above mentioned persons are hereby directed not to perform duty in their posting place. That is what they are saying. Not the regulation is not under challenge. Regulation order is challenged in another petition.
My lord.
Page 100, this may be not properly drafted. That is the difficulty. 100 page, my lord. 99 is the legal notice for payment of salary as contingent staff.
Where is your the cancellation of your regulation?
Regularization, that is, my lord, as page 93.
93.
They have reflected the order also wrongly in the impugn order 17/5.
This, my lord, order
Let me just clarify.
issued on 25th August, my lord. 25th August, next page issued.
Just a moment. Page 93 is the order, 18th of August. Whereas it is brought to the notice of the competent authority that the following employees have been appointed, recruited without following proper procedure at the place of posting as mentioned in the table below. whereas such a post of non-meter. Now, therefore, the regularization order following employees as given below is then cancelled with immediate effect. This is in way back in, my lord, August 2023.
Issued on 25th August, my lord. Next.
Whatever, let me, the honorable court have some queries from me. And consequent to this, we continued, my lord. Then, my lord, will kindly have page 102, the type copy of the legal notice. This order will have to be understood in this context. Since we continued, they did not restrain us at that point of time. Page 102 is the type copy. This is the legal notice for payment of salary, my lord.
But then it's obvious when your regularization is cancelled.
That I have
you
understood,
cannot
my
be
lord.
allowed to continue.
But this, what my learned friend is saying, that is the regular cancellation order that is not so. When we serve this legal notice saying that to our understanding is only the regularization has been cancelled, we should be continued as a contingent staff. That is when we demand a salary for continuing with our work, that is how the 17.5 order came to be passed.
But then your appointment is initially for certain days. And
That
then
is
you
what-
have been allowed to
That
continue.
is what, my lord, that is the fault of the
then
government also.
your service were regularized.
Yes.
But it is found to be illegal. So according to
That
the
I have
authority,
understood.
they have cancelled.
That I have understood.
So this contingency, as a contingent staff, you don't have a right to continue.
That
Because
I
it
have,
has been culminated into a regularization.
yes. That I have understood, my lord. That difficulty is there. That is why, my lord, I am submitting, my lord.
Yes.
Your lordship is exercising equitable jurisdiction. No, my lord, to consider the manner in which these persons have been used. Regularization, is it my fault, my lord?
We'll see
There
on
was a rule.
we'll see on next date.
My lord,
You find
My
your
lord.
affidavit and
My lord will take it with the other.
will stay this direction not to perform. Let them continue
my lord,
as a contingent.
my lord, that part, my lord, now the question will come, my lord, where from the money will come, my lord. Now payment issue will again another issue, my lord. My lord,
When they were appointed, where you have taken, where you have managed the money?
my lord,
Regular payment they are giving.
Is it a case that they were not appointed on sanction post, therefore they have been regulation has been cancelled? Is it your case?
No.
my lord, in that case,
Show us
this-
that they have been, their regulation has been cancelled or they have been terminated because they were not appointed on sanction post or there's no money to pay for their salary.
my lord, that is why, my lord, if it is if the department come up with that clarification, that's.
See,
that's
you
but-
have
but
allowed
before-
the persons to continue for more than 10 years.
My lord, that is why this illegality has been surfaced, my lord, that is the action taken.
It's a matter.
Now, my lord, just to inform, my lord, even in this year, because of the scarcity of the fund, my lord, the months together, even the
Well,
regular teacher,
well-
they were not paid, my lord.
We'll,
Now-
we'll- we'll give you an opportunity to file an application for modification if we come up with the materials to support your submission. And today we are not. You
My-
saw us, this is not a sanction post.
My lord, that part, my lord,
You saw us that they have not been allowed to work as a contingency for
Here-
more than 10 years.
contingency appointment that has been superseded by the impugned illegal regularization. Now, after 4 years, they're coming up,
We are not touching the
Claiming-
cancellation.
my
We
lord.
are only the direction not to continue as a contingent staff.
My lord, that is why, my lord. Now the issue is only the fund, my lord. Where from fund?
You
The
manage,
sanction, my lord, the sanction issue, the sanction post, my lord, it's not there, my lord.
where, from where?
Sanction. my
That's why
sanction-
we'll give you a liberty to approach for modification. Come up with the materials. Are you disputing their appointment as a contingent staff?
My lord, that part, my lord, that has been superseded, my lord.
See, look, the regulation, cancellation of their regulation is on the basis of illegal procedure they have adopted.
My lord.
It's not that they are not eligible. It's not that they have been illegally appointed as a contingent staff. Then, according to you, the regulation was illegal because it has not followed the procedure.
My lord.
It has to have been recruited or regularized through the board. That's the reason.
My lord, that is why only my lord,
You saw.
my lord, the next
you-
date, my lord, fix, my lord, if I have no objection, if there's a contingent, my lord, sanction post is there. My lord, issues only if the contingent staff, if the sanction post is not there, now, my lord,
See, this
punish-
impugn order has been passed only on the ground that their appointment regulation has been cancelled.
my lord, has-
Therefore, you don't work. You don't come for work.
my lord,
Don't perform duty.
my lord, in their.
Contingent is that have
My
some.
lord, that I understand, my lord. Only the issue, my lord, what I'm concerned about is the sanction post, my lord. If this order, if the sanction without sanction post, if it's directed them to allow, my lord, they will be under duress, they will be allowed to work without pay, my lord. That
You
is the
show
one.
us where is
My
what
lord, my lord, you
where
see
it
at
says-
page 107, my lord, 107 of the legal notice, my lord. That has been forwarded to the commissioner and is issued written by the DDSE, Director School Education, my lord. Last second para, my lord. Now they are requesting this office to reinstate into the original post as contingency paid staff and release of their salaries, their wages with effect from so and so till that, if their regulation is not considered. Till that, if their regulation is not
What is the
considered.
reply of the?
My lord, their regulation, my lord, regulation part, even legal notice, they have challenging the cancellation itself, impugn regulation or the cancellation itself.
Oh, no.
But in the legal notice, my lord, if you see the comprehend the entire the projection of the legal notice, my lord.
What is the reply of the commissioner?
My lord.
What is the decision of the commissioner?
My lord, that part I could not, that is why, my lord, let it be fixed on the next date, my lord. That will for better, my lord. If the order, my lord, if it is, there's again going to be hurdles, but that is why, my lord, I'm concerned about. Otherwise, there's no issue. If there's, if by then, my lord, if I come to know that if there's a direction or from correspondence from the authority, yes, there's a contingency sanction for, then I have no objection, my lord. Only an issue, but if once the order passed, my lord, they're allowed, they will come for the salary, my lord. Now the issue again, that where from that salary has to be borne, my lord.
You manage it.
That is what I'm concerned.
Your mighty state.
My lord, recently even
For contingent staff.
2 months together, even regular employee salary were
So
not paid.
I'll give you a liberty to approach for modification
My lord.
with materials. Because I'm not convinced that the regulation, cancellation of the regulation is not based on that they were initially illegally appointed or in a
In that case,
not
my
a
lord,
sanction force.
in that case,
These
my
are
lord,
only procedure, I mean, illegalities, maybe involving something more than that. You cannot.
my lord, in that case, my lord may observe they are maybe allowed to as a function as a contingent staff if the sanction post exists, my lord. If sanction post available, that would be best, my lord. If the sanction post, I have no objection to that, my lord.
We'll see
If exist-
finally. We'll see.
My lord, once, my lord, the manner in which this interim prayer has been made, if it is indirectly amounting the suspending the regulation, cancellation of regulation.
Will not. We'll just simply say that they should be allowed to continue
As
to
a-
perform as a contingent staff,
My lord.
as they were allowed since 2008 to 2010.
My lord.
All right.
My lord. With
Heard,
liberty.
Mr. Deepangi, learned counsel for the petitioners. By filing this writ petition, the petitioners have challenged the order number, page, what is that?
112, my lord.
112, huh? Order number so and so, that is 17/05/2024. Passed by the Deputy Director of School Education, West Siang District, Alo. Whereby the petitioners have been directed not to perform duty in their posting place till further order in view of the cancellation of their regularization in the services with order dated 06/09/2023. Issue notice returnable by 4 weeks.
Regarding interim order, madam, may I observe that I
We are passing in.
vehemently object, madam.
Then-
Madam, kindly observe, madam, that part only, record my part.
Mr. T. Tagum Leonard, Standing Counsel for Education Department, appears entered appearance and accepted notice on behalf of
One,
all the
two,
respondents.
3, and 5, madam. 4 is state, madam, the state deputy commissioner.
1,
One.
2, 3, and 5.
Yes.
And MS GFA for,
For, no, sir, this year.
you are the main person who has issued this impugn order. No, that is Deputy Director.
Deputy-
Oh, sorry. Appears and accepted on behalf of respondent number 4. No formal notice so and so. Heard on the interim prayer. The next paragraph. Petitioners were appointed as contingent staff.
Yes.
What is it called?
Contingent staff.
Contingent
Contingent staff.
were staff since 2008 to 2000. No. In the year 2008, 2009 and 2010. And they were allowed to continue till their services were regularized. When it was regularized,
My petition number 1 and 3 on 22/8/2019
it's okay. In the year 2019, same year,
and 20.
and 2019 and 2020. And please, thereafter, what is that cancellation order?
93, madam.
The regulation order. The regulation orders were
Cancel.
cancelled by the order dated 06/09/2023.
Madam, 18/8/2023, page 92.
Okay, 18/8/2023.
2023.
Issued on 25 August.
Issued on 20/08/2023. Having found that the procedure for regulation of the petitioners were not in terms of the applicable rules and procedure as the services for regulation public appointment of the petitioners has to be through the Arunachal Pradesh Staff
Selection
Selection Board. Mr. Next paragraph. It is the contention of the learned counsel for the petitioner that the services of the petitioner, the regulation of the regulation of services of the petitioners have been cancelled and not the appointment on contingency basis. Please stop. The subject matter, the cancellation of the regulation order has been put to challenge. Orders have been put to challenge in the writ petition
513/2023.
5/1 3
Yes.
of 2022,
23.
which is pending before this court. List of. He submits that since the petitioners have been working more than 10 years, and now nearly 10 years, and so they should be allowed to continue as contingent staff as allowed since 2008, 2009, and 2010 till the matter is finally determined by this court with respect to the issue of legality or otherwise of the regularization of the service of the petition. Next paragraph. Mr. T. Tagum, learned counsel for the
Standing counsel.
learned standing counsel for education is vehemently oppose the submissions of learned counsel for the petitioner. No, has and vehemently oppose the prayer for interim prayer for interim, and had strenuously submitted that since the services of the petitioners have been, since the regulation of the petitioners have been cancelled, and they cancel, therefore they are no longer in they cannot be allowed to continue even for or even on contingent basis. As there's no fund there's no fund for payment of salaries to the petitioners if they are allowed to continue. Next page. Consider the submissions of the learned counsel to the parties. List of. Next paragraph. For the purpose of consideration of the interim prayer. List of next paragraph. Considering that the petitioners were appointed way back in 2008, 2009, and 10, and have been allowed to continue on contingency basis till their services were regularized. Although the regulation have been cancelled, regulation orders have been, which is the subject matter to be determined in the petition within bracket supra, coupled with the fact that the petitioners have been continued for more than 10 years as a contingent service. Coupled with the and subject to the final determination of the cancellation of their regular service, I deem it appropriate to allow the petitioners to continue. I deem it appropriate to direct the responding authorities to allow the petitioners to perform their duty in their respective places of postings, in their respective place of postings as contingents on a contingency basis. Listed accordingly. In the interim, it is directed that the petitioners shall be allowed to continue as contingency staff. . till in other words, the list of, till returnable, we'll see, till returnable date, we'll see, till returnable date. It is, in other words, the impugn order dated 17/05/2024, directing the petitioners not to perform duty in their in their place of posting. Posting place is suspended.
My lord,
return-
there's
till
my
return-
confusion, my lord. The second word, my lord, that's added, that makes great confusion. My lord, the 17 May order, it is a follow-up of the original order passed by the commissioner, my lord. That's
You-
only.
You could
My
not.
lord, that first order will do, my lord. That will suffice, my lord.
Okay.
My lord, once it made inference in different way, my lord, that
Okay.
indirectly, my lord, because this is order, it is not.
So in that case, you allow.
My lord, this is not independent order, but this order is based on follow-up order of the
Which one?
commissioner.
Which one?
The termination order at page, my lord, this is the,
It's referring to 17/5.
that is, my lord, see, this is the order with reference to 93 of order, my lord, 93, my lord, page 93.
It's okay then, in that case.
That last part, my lord.
Liberty is granted since the learned council, learned standing council has strenuously has seriously prayed for placing the relevant materials on the next date. Liberty is granted to the respondents to file appropriate application for modification of this order. In the event, if the respondents has the materials, the materials to support their submissions.
My lord, may we take along with the other
This matter along with
513.
513 of 2020.
Okay.
May my lord.
Yes.
I'm appearing for respondent number 2, my lordship. We need
Yes.
some more time, my lord, to file affidavit.
For what?
For affidavit.
This is what? Writ petition.
Yes, my lordship.
What is the matter?
Your lordship, this is about land compensation, Your lordship. Land compensation.
Service completed. Service complete.
Yes, your lordship.
Okay. Heard, Mr.
Your lordship, I have some submission to make. Your lordship, respondent number 2, DC of Anjao district, they have already filed their affidavit in a different matter, WPC of 44
It's up
of
to them.
2024,
We are not-
which is related to the same.
It's okay. Heard, Mr.
And your lordship, one more submission, your lordship. These
What's
three,
your name, please?
E-Pine, your lordship.
Ipaying, Learned Council for the petitioners. Petitioners.
Yes, your lordship.
Next para, MSK Wang Learned State Council, phrase foreign is granted 3 weeks time to file affidavit. List after 3 weeks.
One request, your lordship. 3 matters are similar and they may be tagged together.
Let this method be listed along with writ petition number.
Yes, your lordship. 44 of 2024. Writ petition 160 of 2024. And writ petition 202 of 2024.
4 writ petitions.
Three. This one is 202 of 24.
You just read, list this matter along with writ petition 44 of 2024 and writ petition
160.
160 of 2020. That's
Yes.
all.
Deeply obliged.
May I plead?
Yes.
This matter relates to non-compliance of order
Yes. Who appears for the contemptor, Alice contemptor?
Yes.
I'm appearing for respondent number one, DC.
Hmm.
DC.
Order dated 10/3/2023 is in page, may I read from page 27? And the
Just
operator,
wait, just wait. We have filed the affidavit.
yes, we have filed, affidavit of service on
Mhm.
17/6/2024.
So how many respondent?
Three contemptor. 1, 2, 3.
You are only for one.
Yes, ma'am.
Heard Mr. Esmo, learned counsel for the petitioner. Petitioners,
Yes,
how many
Petition-
petitioners?
around
68 petitioners, huh?
30 petitioners.
Next period, MS. K. Wangmo, learned counsel. Entered appearance of respondent number one.
Yes.
Then, have you complied?
No, my lordship, we need
Did
some
you-
more time, my lordship, file affidavit.
And press for press for and is granted 3 weeks time to file response to the contempt petition. Next paragraph. Mr. Esmo, learned counsel. To the learned counsel submits that he has filed an affidavit.
Of dusty service.
No, please stop. No, you just last line. A proof of justice service has been. And affidavit for proof of justice service to the respondent number 2 and 3 have been filed by the learned counsel for the petitioner. Learned counsel will come up, which is taken on record and is accepted. Mr. Accordingly, the service upon respondent number 2 and 3 is complete. However, none appears to the respondent number 2 and 3. List this matter after 3 weeks.
No, like.
Mayor, please, ma'am.
Yes.
My lord, last time it was
Press
listed.
step.
Press step, my lord.
You're
With
supposed to take-
apology, my lord, there was a
Mr.
direction.
Learned counsel for the petitioner. Press for and is granted 3 weeks time to, it's 3 days time to take press steps for service of notice upon respondent 2, 3, and 4.
My lord.
List this matter after,
Interim, my lord.
list this matter after 4 weeks. No, before that, there for 3 days, huh? Press steps granted 3 days to take press steps for service of for notice for service of notice upon respondent number 2,
2, 4.
2, and 4.
2, 3, 4.
2, 3, and 4.
Man.
Within 3 days. Rest of they have to register to issue notice. List after 4 weeks.
Interim order is there.
Interim order was will continue.
Highly obliged.
What is this?
This is the compensation matter, my lord.
Where did you last, who is respondent number 7?
The private
You are
respondent.
there.
Yes, sir.
Then
Steps is completed.
what Mr. B. Piche, learned counsel for the petitioners.
Petitioners.
Mr. Have you filed the
No, your lordship, we need some more time, your lordship, for filing. for
MS
affidavit.
P. Pango, learned state council appearing for
respondent
the
number three.
state respondents and Mr.
Emily.
M. Millie, learned counsel appearing for respondent number press, have prayed for and is granted 3 weeks time to file affidavit. Just after 3 weeks. Ah. It's not there. How many are on this? Okay.
Lordship, I beg to mention item number 3 and 4. Lordship, I may be allowed to withdraw that writ petition with the liberty to file fresh.
Okay.
Today's item number 3 and 4.
Not amendment.
Not amendment. Earlier I said amendment.
Item 3 and 4. Same order. Ah.
It may be given a liberty to
Ah,
file fresh.
Mr. T. Tabalan, you just check in who is there. You just check out item 3 and 4. Mr. T. Tabalan, counsel for the petitioner, submits that he may be allowed to withdraw the writ petition with a liberty to file a fresh list. The prayer of the petitioner. The prayer is accepted. Please accordingly. Writ petition stands disposed of on withdrawal with a liberty as prayed for.
Deeply obliged.
Both the
Item number
cases.
3 and 4.
Ah.
Both. Deeply obliged.
Lordship, item number 11 and 15 may be taken up together because this is connected matter.
15.
11 and 15
Okay.
at later stage. Item 11 may be taken up along with.
Contempt will issue notice. What's there? Is there any violation?
Yes, there was an order passed by dishonorable court on 26 not to issue fresh NIT. But on 27, fresh NIT has been issued by the respondent authorities.
Have you served the copy of the order? So we'll issue notice here. In any case,
Yes, Lordship.
notice has to be issued.
Yes.
Heard Mr. K. Learned counsel for the petitioner. Next paragraph. This is an application under section 11 and 12 of the Contempt of Courts Act, 1971. Article 215 of the Constitution of India.
Recipient. Email. 27 koi diya na.
Alleging willful and deliberate violation of the order dated 26/6/2024, passed in WPC 254 of 2024. Expiry issue notice. Returnable within 3 weeks. 3 weeks. 3 weeks. Next para. The then is consulted to the petitioner shall take a stage for survivorship notice upon the respondent. Sole respondent.
Sole respondent.
Oblique, alleged contender within 3 days from today. By registered post with the AD so and so, as well as the DJ process. This after 3 weeks. Then 15.
Lordship,
15 is a different. Why this is connected? 15, item 15.
my lord. What happened, my lord, on 26th of June, my lord, this honorable court passed an order, my lord, by restraining the respondent from issuing any retendering with the subject tender, my lord.
Yes.
However, on 27th, my lord, they have issued retendered, my lord.
Yes.
My lord, we are challenging that NIT, my lord. Lordship will find the order, lordship, at page 181, my lord.
181.
Yes, my lord. Is the order, my lord. The operating party lordship will find at page 183, my lord, last paragraph 12, my lord.
Yes.
May I read, my lord?
Page.
183, my lord.
Yes, yes.
Last paragraph 12, my lord. It starts from page 12, direction, my lord.
Yes.
And my lord, page 185, my lord, they have issued the written notice, my lord. With regard to
Page
185, with regard to same
85.
work, my lord.
Have you furnished the copy?
My
This
lord,
copy to when did you furnish?
my lord, I furnished on 27th, my lord, because I was awaiting copy of certified copy this was issued around 6 PM, my lord. And immediately I made a representation, my lord, at page 180, my lord. We have communicated that the order has been passed, my lord. The order was passed in the presence of the council, my lord.
Why press writ petition?
But we are challenging this NIT, my lord, notice, my lord, at page 185, my lord.
On what ground?
My lord, this is in, my lord, if it is not stayed, my lord,
No, if it is in violation, we have issued a notice.
but my lord, if it is not stayed, my lord, then they will proceed.
You could have filed an IA in the writ petition. Writ petition is pending.
It is pending, my lord.
Yes.
But my lord,
It's not question of a different challenge, only violation. He has, is there any change? Are you challenging this retender on any other grounds?
my lord, lordship will see the reasons, my lord. Reasons, your lordship will see the reasons. It is given, my lord, retendering action due to technical oblique administrative reasons, my lord. There is no reason at all, my lord, in the tender process, my lord. And my lord, if required, this board may take together, my lord. This board petition may take together.
No, this court is of the way. You could have filed an IA in the writ petition.
But my lord, maybe it might be wrong opinion, but my lord, if
Why unnecessary burden these huge copies of the papers?
my lord,
If you are challenging it other than the violation of the court's order, better would have been different.
my lord. But my lord, lordship, I have taken one of the ground, my lord, that does not contain any reasons, my lord. That notice does not contain any reason, my lord.
Okay, in that case, we will issue notice and take with that.
But my lord,
Right.
but my entry may be considered, my lord. I'm praying for staying of this NIT, my lord. Otherwise, they will proceed, my lord. They finalize it, my lord. And that's why I have also filed a contempt with item number 11, where lordship has issued notice, my lord.
Mr.
R.S. Mishra, my lord.
Who is appearing for a respondent?
Copies will served, my lord.
Served to whom?
My lord, CGC, my lord.
Who is CGC? Mr.
R.S. Mishra, my lord.
R.S. Mr. Learned counsel for the petitioner. Petitioners.
My lord.
Where is the tender? The
My
non appears despite the non appears for the respondents. Despite service of notice to the learned counsel for the respondent, right?
My lord.
Despite copy served to the writ petition copy served to the learned counsel for the respondents. Next paragraph. Page, where is that page?
185, my lord.
185. The no, not the petitioner has challenged the impugn retender notice dated 27/06/2024 passed by the SC within bracket CIB bracket close page 185, huh? Or chief engineer for execution of contract for. This is what sort of nature of the works?
No, this is basically my coating of road, my lord.
Execution contract for execution of contract for surfacing works, so and so, page 85 is just right. Next paragraph. Learned counsel for the petitioner submits that the disputes with regard to the same tender is the subject matter, and writ petition being WPC, which was that?
My lord, page 181, 254 of 24, my lord.
254 of 2024, which has been stated by this court by an order dated 26/06/2024 has issuing notice has directed the respondent authorities not to retender the said execution of contract without the leave of the court. Mr. However, by the impugn retender notice, the respondent has violated the order of this court, for which the petitioner has already filed a contempt petition, and a notice has been issued to the respondent authorities. Mr. Next paragraph. Issue notice to the respondents returnable by 4 weeks. Next paragraph. Considering that this court has in clear terms directed the petitioner and the respondent authorities not to retender the execution of the contract as mentionable, and not to retender the execution in the contract. When interim order dated
26.
26/06/2024. The impute retender notice was by the SC within bracket CID so and so, direct within the contract for chief engineer, dated 27/06/2024. Shall remain state till returnable date. The rate petition be listed along with rate petition number 253.
254, my lord.
252 for 2024.
24. DP of the.
Okay. Item number 12.
Yes.
May I please, Lordship? Lordship, the petitioners before your Lordship is aggrieved by the order first issued by the EAC, Naharlagan, while executing the decree passed by the Blaze authorities,
Where
has
it is?
passed a status quo order
Where it is?
against the petitioners.
Where it is?
Impin order,
Yes.
Lordship, page 52.
52.
Yes.
Yes.
May I read, Lordship?
Yes.
The execution suit number 1 of 24 in between Srimati Ligang Dumi versus Tabatakar. This is the execution petition between this party. The Srimati Ligang Dumi is the respondent number 1 in this present case, and Sri Tabatakar is the respondent number 2, Lordship. Sri so and so, the counsel for the decree debtor, Sri Tabatakar, present and reiterated that they have filed a civil revision before the Honorable Guwahati High Court, Itanagar, by case number so and so, praying for setting aside the impugned ex-party mail order of the Blaze Authority dated 18 July 2023. The Honorable High Court admitted the aforesaid civil revision petition and issued notice to the respondent so and so on 2/4/2024, and a step was taken through AD card on 12/4/24. The learned counsel also filed an objection pertaining to maintainability of the instant execution suit, submitting that all the statements of the decree holder are inconsistent and contrary to the records. E.R. Junkar Gamdil, he is the father of present petitioner number 2, Lordship, appeared and stated that the said land was purchased by his son, Sri Karbangamdil, and further shown documentary evidence of the payment made for the said land. As per record, on 16/6/23, the first installment of rupees so-and-so was paid to Srimati Tabarinyo, wife of so-and-so, and full and final payment amounting to so-and-so was again paid to Srimati so-and-so on 16/12/2023. Further, he informed that Sri so-and-so, after discussion with his wife, Srimati so-and-so, had clarified that the plot of land earmarked for Srimati Ligang Dumi is located adjacent to his plot and includes some portions of the extended land of Sri Minligai. As such, he prayed that his son may not be implicated in the instant execution suit. Sri so-and-so could not attend the hearing physically as he was attending 2 weeks training, but divorced his statement through mobile phone. He stated that he had already obtained LPC in the year 2008, but 2 years back, he purchased additional plot of land for extension of his existing plot from so-and-so, measuring about so-and-so only. He also submitted that he has already constructed boundary wall and 2 wells on the extended plot, but Srimati so-and-so had never raised any objection. Further, Sri so-and-so also denied any knowledge about the land dispute between so-and-so and afraid that his name may be dropped from the instant execution suit. In view of the above, all parties are required to appear to answer all for final hearing on 9 July at 3 p.m. It is status quo as on 24/6/24 to be maintained by all concerned. No further construction activity shall be taken up till next hearing. Now, what happened, Lordship? Brief fact of the case. There is a land dispute case between the respondent number 1 and 2, who is the party in the execution suit.
Yes.
Now, the land dispute between the respondent number 1 and 2, wherein the respondent number 1, she claimed that she has purchased 980 square meter of land from the respondent number 2. And they have executed sale deed.
Yes.
But the possession of the land has not been handed over to the respondent number 1 by respondent number 2. Accordingly, the respondent number 1 filed a complaint before the Blaze Authority of Model Blaze. May I take you to the complaint at page 34, Lordship? Page number 34.
So
This is the first complaint.
your lender within this disputed area or not?
Adjacent land. And very interestingly, Lordship, had my land within that disputed area also, I should have been called in the Kabang proceeding. Now, this is at the execution stage. When Kabang was held on 18/7/2023, both the petitioners was never implicated as a party in the said Kabang. Kabang was passed in favor of the respondent number 1, and for that, she has filed the execution petition before the EAC Naharlagan.
In the Keba decision, whether your lands are involved.
No, Lordship.
Then,
Yes, Lordship. Therefore,
if
Lordship, that's-
it is for execution of the Keba, and if your lands are not touched,
Lordship, yes,
what's
Lordship.
your problem?
Now, Lordship, that's why, Lordship. This is the complaint at page 34.
Yes.
May I take you to this complaint, Lordship?
So according to you, by this, the executing courts will be executing, including your affecting your land.
Yes, Lordship. Now, what happened in the execution court, before the executing court, the respondent number 1 filed one fresh application, Lordship. Page number, Lordship, 49.
Yes.
This is something like IA application, maybe she has filed in the execution suit. May I read, Lordship? By the order
Let us say
18/7.
the Keba decision. Now by this, he said the other person has sold the same plot to other 2 persons.
Yes,
including
now
what-
she at the execution stage, Lordship. Now she are claiming it.
So where is the Keba decision?
Lordship.
Keba decision is where?
Cover decision, Lordship, at page 39. This cover decision mail order was also passed ex parte against the respondent number 2.
What does it say?
May I read, Lordship? Whereas a mail
Just
was
tell us where any decision affecting your land.
no, nothing, Lordship. Here, the operative person is at last para, Lordship. Therefore, power conferred under section so and so, so and so.
24
I see it, Tichi Murki, Headgown Bura Model Place, Naharlagan, do hereby pass this order against Sri Tabatakar, respondent number 2, to refund back the said amount of rupees so and so, along with interest as per bank norms, or to give possession of his land measuring an area 980 square meter situated at Model Place near Halifax within 1 month. This is the Kabang mail order, Lordship.
So this 980 square meters, where is your land? Is it within this 980?
No, this is at the very first time, for the very first time in the execution proceedings. Now, the respondent number 1, they are claiming that some portions of her land has been occupied by both the petitioner. But it was not before the Kaba.
No, this 980 square meters,
Yes, Lordship.
how your lands falls within this 980? Your land?
No, Lordship. To me, my land is under my possession since I have purchased from the
No,
respondent.
practically whether it falls within this 980 square meters. Your-
As per her claim at this stage, yes, she is claiming that some portion of our land falls within this land.
according to you, whether it falls within this 980,
No, Lordship.
then
I have constructed my wall boundary
then
wall,
you are no, you cannot be aggrieved.
Lordship.
Then you cannot be aggrieved. How you are aggrieved?
Now they are stopping my construction work, Lordship, by the executing court, Lordship, by infin order. Now the question is, Lordship, since the Kaba mail order was passed in between the respondent number 1 and 2,
It's okay, but then why you have appeared and why you are claiming that how you are aggrieved? If your land doesn't fall within this 980 square meters, how you are aggrieved? Execution will be within that only.
now before executing court, Lordship, she has filed fresh application and saying that some portion of our land, which is in our possession, even both the petitioner have already constructed their boundary wall also, Lordship. The petitioner number 1.
Are you sure it doesn't fall within 980?
Now she is claiming that land, some portion.
Forget the claim. What about you? You must be knowing.
For me, Lordship, no, Lordship.
It doesn't fall
I have
within
purchased-
980.
Yes, Lordship. I have purchased from the respondent number 2, and even I have constructed boundary walls within my
Respondent
area.
number 2, in the sense that Mr. Takar.
Taba Takar, yes.
So this petition, execution petition has been filed by
By respondent number 1,
respondent number 1.
Srimati Ligang Dumi.
Okay.
Before Kaba, before mail, she claiming that she has purchased 980 square meter land from the respondent number 2.
Yes.
Yes.
You,
Accordingly,
you also purchased from, you have also purchased from
Tabata.
respondent number 2.
yes, respondent number 2, Lordship.
I think the executing court will not go beyond the.
Exactly, that is my Lordship.
No, he has not gone, but then he has said, considering the disputes,
No,
only to
Lordship.
maintain status quo.
Yes, status quo.
He cannot obviously decide the dispute also.
Yes, Lordship. Now they are stopping me from construction activities, Lordship.
Who?
The executing court. By impugn order, Lordship. No
Not
further.
Mr. K. Learned Counsel for the petitioners.
Yes, Lordship.
By filing this revision petition, the petitioners are aggrieved by the. No, the petitioners have challenged the order dated 24/06/2024 passed by the. Who is this? Extra Assistant Commissioner Naharlagun.
Now he is the executing court in terms of civil court cycles.
Weber. The parties have been directed to maintain the status quo pending the final hearing on 09/07/2024. In the execution proceedings
Execution
being
suit.
execution suit 01/2024. By in the execution proceedings being execution suit number 01 of 2024. Between the respondent number 1, respondent number 2. Mr. Next paragraph. The petitioners claims that they are not the party to the Keba proceedings, which was held on
15/7/
15/7/2024.
2020.
18/7/2023.
Mail was held on 15, but or decision was passed right.
Keba proceedings and decision dated 18/07/2023. Whether the Keba has decided. Keba or what?
Mail, Lord.
Mail.
Yes,
Mail, huh? You just in place of Keba, you write mail, huh?
mail, no problem.
Mail has decided against the respondent number 1 to refund back the an amount of rupees 24,50,000 along with interest as per bank norms, bank rate, or to give possession of his land measuring an area of 980 square meter situated at Modi village, Naharlagan, within 1 month from the date of decision. To the respondent number 2.
Yes,
What is sentence you read this? No, second para. Petition. They are not parties to the mail proceedings. Not handed over to give possession of
yes.
his land measuring
980.
980 square meters within 1 month from the date of decision to the respondent number 2.
And before that, mail has passed order against respondent number 2, not 1. First page. Mail order against, mail passed the decision on 18/7/2023 against the respondent number 2. Yes.
The learned consent next para for the petitioners submits that by the impugned order dated 24/06/2024, the executing court has exceeded its jurisdiction by fixing the date and by fixing the and by directing the parties to maintain the status quo as it affects which resulted in affecting the petitioners from construction of his constructive activities over their land as the land of the petitioners does not fall within the area of 980 square meters belongs to the respondent number 2. Respondent number 2.
Yes.
Are you sure?
Lordship,
Respondent number 2. Are you sure that your land doesn't fall within 980 square meter?
Lordship, since that I cannot sure now, but I have purchased from them respondent number 2. Thereafter, I have constructed boundary wall within my land, and from that day, the land is under my lawful.
Now, in that case, if you are not sure, what is that last order? exceeded his jurisdiction.
Exceeded.
As it affects the rights of the petitioners of their lands who are not party to the proceedings.
Yes.
It's the issue notice returnable by 4 weeks. The learners consent to the petition shall take its test for service of notice upon respondent number 1, 2, and 3 within 3 days from today by registered post with AD. Next matter. Considering that
3 days.
the petitioners are neither party to the mail proceedings nor obviously to the execution proceedings, being execution suit 01 of 2024, the impugned order dated 24/06/2024 shall not we cannot fully stop this hearing. We cannot stop.
Lordship, in that case, Lordship, again, the execution, the hearing on execution should have been fixed on 9. And they issued a summon to us and asked to appear on 29.
You file an application that
Lordship,
we cannot
since-
be made
Lordship,
affected.
This is
We'll make
totally
it clear.
beyond, travel beyond the jurisdiction conferred to the executing authority. So why, Lordship, petitioner should be suffered to appear
Then
unnecessarily?
considering that the petitioners to the execution proceedings, execution number 01 of 2024, coupled with the prima facie view that the executing court has exceeded its jurisdiction. Come on, in the interim, it is in the interim, the till returnable date, the impugned order dated 24/06/2024 shall remain state.
And Lordship,
It is made clear that the executing court may proceed with the respondent number 1 and 2.
Respondent number 2
the executing court may proceed with the execution proceedings in respect of respondent 1 and 2. Is that it?
yes.
Respondent 1 and 2.
Two.
Next, since the interim order is passed without hearing the land, without hearing the respondents, liberty is granted to file appropriate application for modification if so advised. We cannot stop the
Yes,
proceedings.
yes, Lordship.
They may proceed with the
Yes, in between the respondent 1 and 2.
but there will be a problem. He will not be able to proceed. I'm sure this is the same plot.
Maybe, Lordship.
It appears to be.
Yes, but for that also, Lordship, I should be called in the trial court
Okay.
to decide my right also, Lordship.
Ultimately, you will have to go to trial court. All of you. Yes.
Deeply obliged, Lordship.
Next. Heard Mr.
S.A. Shikdar, my lord.
S.C.
S.A. Shikdar.
Siddharth.
Shikdar.
S.C. Siddharth. learned counsel for the petitioner. This is an application under section 439 of CRPC 1973 for praying for bail, praying for post-arrest bail to the accused person. What is the name of the accused person?
My lord, Forest Deca.
Accused person,
Accused person Forest Deca.
Perez Deca.
My lord.
Perez Deca, in connection with Pasigat PS case numbers 77 of 2024 under section 399, only 120, bracket, capital B, bracket close, IPC, 1860. Who was arrested on 04/06/2023. Call for the case diary. Call for the case diary. MS L. Hage, learned additional PP. APS for the state. List after
My lord,
2
on-
weeks. 2 weeks.
My lord, on the fixed date kindly, my lord, on 16. On 16, my lord.
Yes, but then your new criminal law have come into force from
Yes,
today.
but my lord, this offense was committed earlier, my lord.
It's
That is-
okay. Offenses we may,
Yes, ma'am.
but then
That is
the
okay.
application
My lord.
is the same application, the same section.
Lordship, this is registered lordship, earlier lordship, after
Earlier.
implementation of this.
When it was registered?
My lord, it was registered, my lord, on,
No, your bail application
my lord, today, my lord.
today.
My lord.
Today it has come into effect. New criminal law.
Then I will put the new, my lord, act, my lord.
Otherwise, it will be acting like an opposition.
My lord. And I will put, my lord.
Huh? Which is the provision? Yes, which anybody
83, my lord, 483, my lord, now.
who is regularly in the criminal side, practicing criminal side.
Now, my lord.
Yes, what is to be done? New criminal laws have been come into force from today, and this is a bail application under the same old act.
But case was registered earlier,
It's okay. Case registered we may.
my lord.
Offense to we are not.
My lord, my lord,
I mean, under what provision? We cannot say CRPC now.
my lord. That is true.
Application should be filed under new law.
New law.
So, my lord, I will put the new government. I will put the, my lord.
What is
new
the
act,
new
my
law?
lord. New act, my lord, I will put, my lord. In place of, my lord, CRPC, my lord.
This court would like to know also which is the provision, new
Because
provision.
actually, my
Yes,
lord,
madam. Do you know? Don't you have?
Lordship, actually, today I did not bring lordship.
Yes, you could have.
Lordship, it's my.
Did you
mistake.
know that it is?
Lordship,
It was supposed to come into force. It has already been.
lordship.
The debate is going on in parliament. That is another issue. But it has been. It has notified. It has been notified.
notified.
These are the things we'll have to be. We'll have to adapt and up to date ourselves. Anyway, let us for today. We'll see. We'll find out.
Lordship, my lord.
Get the new act, huh? New criminal law.
My lord.
List after 2 weeks or 1
Kindly
week.
Kindly fix a date, my
List on when?
lord. On 16, my lord, kindly.
16.
My lord.
16/07.
In the meantime, case diary will confirm. Oblige.
Apply.
Yes.
My lord, the petitioners are statistical investigators.
Hmm?
My lord, the petitioners are challenging the appointment of respondent number 5 and 6.
Why?
Because they have been appointed to the post of statistical investigator without following the relevant recruitment rules or law. And the petitioners are also challenging the promotion order of the respondent number 5 and 6 to the post of statistical officer, your lordship.
Hmm?
They are also challenging the promotion of the private respondents to the post of statistical officer, your lordship.
Statistical.
Officer.
Appointment order as well as promotion.
Yes, your lordship.
Where is the impugned order first?
My lord, the appointment order is not here, your lordship. The petitioner is challenging the promotion order
Promotion only.
as well as the appointment order, your lordship. The appointment order could not be procured, your lordship. The appointment can be seen from the seniority list, your lordship.
Seniority list also.
Yes, your lordship.
Appointment and seniority list.
Yes, your lordship. And
Your
as well as
challenge
the,
is,
yes, your lordship, their appointment to the post of statistical investigator, your lordship.
then
And then their subsequent promotion to the post of statistical officer, and as well as the seniority list of statistical officers, your lordship, where the respondent number 5 and 6 were placed in at serial number 64 and 65.
there is no appointment order.
No, your lordship. We
You
had
are
filed an
tell-
RTI, but we could not, we had not received any
Where it is, how do you, from where we get this
from the page number 99, your lordship. This is the,
99?
yes, your lord. This is the final seniority list of statistical officer, your lordship. Page number 103. Oh, sorry, I'm sorry, 104, your lordship. The last serial number 64 and 65. Their appointment
104,
your lordship. Their date of entry to the post of statistical investigator can be seen at
104.
yes, your lordship, 64 and 65, serial number 64 and 65.
Date of appointment.
Yes, your lordship.
Who are the respondent 5 and 6?
At Bijum Bogo and Mowa Jugli at serial number 64 and 65.
64 and 65.
Yes, your lordship.
Why you are aggrieved by their appointment?
My lord, they were appointed without following any procedure, your lordship, selection procedure against the recruitment rules, which provides for 100% by way of direct recruitment, your lord. to the
Where the
post-
seniority list? This is the seniority list.
Yes, your lordship. This is the seniority list of statistical officer.
Okay.
They were initially
You
appointed.
are what?
We are statistical investigator, your lordship.
Then how you can challenge the seniority list of
My lord,
officer?
we are aggrieved because if this statistic, if they are given a go by, your lordship, they will be given an opportunity to still march over us, your lordship, to the next higher post, that is of senior statistical officer, your lordship.
At this stage, only notice may be issued.
Notice, okay, notice. Or Mr. Ms. Dita learned consent for the petitioners. How many?
24 petitioners, your lordship.
Petitioners. You are what
Statistical investigator, your lordship.
statistical inspector,
Investigator, your lordship.
investigator. Next para. By filing this application, the petitioners have challenged the appointment 24/8/2022.
Yes, your lord. This is the
Appointment.
there is the promotion order, your lordship.
Okay, where is that appointment order?
Appointment order is not here, lordship, but then from this,
Are you challenging the appointment?
yes, your
order?
lordship, I'm challenging the appointment.
Appointment orders and the consequential promotion and the promotional order dated 24/08/2022
Yes, your lordship.
issued by the Commissioner within bracket Economics and Statistics, Government of Arunachal Pradesh of the respondent number 5 and 6 and also the seniority list
Yes, your lordship. Of statistical officer.
of statistical officer dated 15/01/2024. You are not promoted as yet.
No, your lordship, I'm
Then
not.
how you can challenge this their seniority list?
My lord, the petitioner, they have an apprehension that in the meantime,
You are yet to be promoted as a statistical officer.
yes, your lordship.
Then you cannot challenge this.
My lord, if this,
Promotion and appointment, we can understand.
but then your lordship, if this seniority list is followed, your lordship, the private
See,
respondents.
you are still statistical investigator.
Yes, your lordship.
Next higher post is statistical
Officer,
officer.
your lordship.
They have been wrongly or rightly, they have been promoted.
Yes, your lordship.
The promotion and the appointment, we understand, but then since you are not the cadre of a statistical officer, how can you challenge the seniority list?
My lord, since the respondents were appointed dehoors the recruitment rules, your lordship, that is why.
Still then,
And then,
that is a subject matter to be determined. We're yet to determine.
yes, sir. And then,
Anyway, it's just, but then long run we cannot. And also, the seniority list of statistical officer dated 15/01/2024. That's all. Issue notice returnable by 4 weeks.
my lord, there's a similar writ petition pending, your lordship. This may be tagged along.
Issue notice, returnable by 4 weeks. MSK Wangmo London State Council enters and accepted notice on behalf of respondent number
1 to 4.
respondent 1, 2, and 4. Then 5 and 6, the next no format since the London Council, London State Council. No, you just said MSK almost so and so, London State Council appears and accepted notice on behalf of respondent number 1, 2, 3, and 4. No format notice need be served. Our extra copies, Next period, the London Council of petitioners to take steps for service of notice upon respondent number 5 and 6 by registered post with AD, as well as usual process within 3 days from today. List after 3 weeks, along with 4 weeks, along with writ petition number
166 of 2020.
166 of 2024.
Yes, sir.
Yes, next.
Obliged.
15. 16. Yes,
May I please, Lordship?
yes.
May your lordship. Your lordship, in this, regarding this matter, we have filed caveat, your lordship.
Okay.
So we are the caveator, lordship, and the main counsel for the caveator, Mr. T. Garam, is out of session due to medical issues, your lordship. And your lordship, if any other passed by this honorable court today, it may be, your lordship, it may be affect the parties, your lordship. So I humbly pray, your lordship, that this matter may be listed after vacation and maybe on 15th
We'll
July.
hear you, we'll hear you. What is there? You file a caveat and you remain absent. What's this?
May I please, Lordship?
Caveat is not for adjournment. Caveat is to be heard. You should be heard. So we'll hear you today. Are you ready? Do you have the petition?
Your lordship, I'm
Do you
not
have
ready.
have you served the copy?
Yes, Lordship, I have served.
Your lordship, I'm not the main counsel of this
Doesn't
matter,
matter.
your
We'll hear
lordship.
you. You have signed the wakalatnama.
No, your lordship, I'm
You sign it. Now you sign it. In the caveat will discharge you. What is this?
your lordship, I'm not
May I
ready
please?
for this.
May I please?
What is to be done?
Lordship, the matter is very urgent in nature. Yes, because Lordship, in writ petition number 51/24, the Honorable Court, after conclusion of the hearing, page number, Lordship, 43 of my writ petition. 43 of my writ petition. Lordship, here, this Honorable Court has directed that accordingly, we remand the matter back to the Director, Rural Development, to undertake an exercise of approval of the recommendation made by the project director DRDA Kurunkume district in respect of tender NIT date number 21/8/2023 for procurement of material pertaining to MG Narega works 2023-24 for CD block Polosang under package number 8. The said exercise shall be done within 2 weeks from the date of receipt of this certified copy of this order. This is the order. The order is in favor of the petitioner, Lordship.
Where
But-
it is, where it is? Page
Page number 43.
43.
Yes, this is the relevant portion, para 23. Page number 43, para 23. Lordship. Thereafter, hearing this judgment and order, this honorable court has clearly directed that the petitioner in WPC 5124 being agreed with the letter of intent issued to the private respondent number 8 has filed a writ
So what happened thereafter?
thereafter, despite of this clear order, speaking order, page number 44, that is annexure 9.
Remand back to the director department to undertake the action, approval of the recommendation
Yes, Lordship.
by the project director, DRD Kurunkume in respect to fulfilling. Yes.
And project,
This is in your favor.
yes,
Okay.
project director has declared my bid as L1. But despite of compliance of this order, the respondent authority in page number 44, they have again issued letter of LI, letter of intent, LOI, on dated 21 June 2024,
This is the,
in violation of this order.
21 June.
Yes,
And this order is,
this order is of 24/5/2024. We have also supplied a copy of this order, certified copy of this order.
nothing has been passed.
Lordship.
Nothing has been passed.
Lordship, they have, this honorable court has directed,
Then after the order of this court, that is 24/5/2024, no order has been passed,
no order has been passed.
is it?
Yes, thereafter, the respondent has issued this impugn order, that is page number 44.
Without considering
Yes, without considering this,
without doing any exercise for approval.
yes,
Exercise
yes,
was carried out.
Lordship.
Exercise was carried out.
Yes.
My lord, may I please come to page 41
40.
of the writ petition. This is the judgment. Para 16, ma'am.
Yes.
May I read, ma'am? Therefore, from 15/3, so it appears that the Director of Road Development Engineering Wing is merely authorized to make scrutiny of the tender documents recommended by the ADPC, and that it is prescribed that the letter of intent will be issued to the L1 firm duly recommended by the ADPC, and that the project director is required to issue supply order to the successful bidder on the basis of LOI issued by the accepting authority. Therefore, it is not found. Therefore, it is not found as to how the director so and so has the authority of summarily rejecting the recommendation made by the project director come ADPC. my lord. First, my lord, summarily. Now, para 17, my lord. While rejecting the proposal sent by the project director DRD Kurunkume district, the director so and so could have disclosed in the decision-making process the reasons for not accepting the recommendation and to recommend the bid submitted by the respondent number 8. In the absence of any such note, no process or no reasonable exercise was carried out in this case. In the absence of any such note in the office file of office of the so and so produced by the standing counsel for the respondent number 2 to 7, the court is inclined to hold that the stand taken by the said respondents in their affidavit opposition and in their additional affidavit is not in conformity with the materials available on record. It is well settled that the decision must be examined on the basis of contents of the document itself and not on the basis of explanation tendered thereafter. Now, my lord, may please come to page 43, my lord.
Yes, read it.
Top, my lord. Hence, the court is of the view that it was not often for the said authority to substitute its view taken by the project director so and so without any justifiable reason. Page 43, my lord. Meaning there, my lord, in that case, my lord, no justifiable reason was given, my lord. Without any justifiable reasons being disclosed either in the order dated so and so or in the note sheet of so and so and the e-note sheet number so and so generated on so and so, which are the only two note sheets available on record of this particular file produced by the so and so. On the basis that there was no justifiable reasons, my lord, this honorable court had interfered and remanded the matter back to the department, my lord.
To undertake the exercise of approval of the recommendation.
Yes, my lord. Now, my lord, while filing the while filing our affidavit, my lord, in opposition, we failed to produce this order, my lord. This is
No, we are not re-examining that.
Yes.
My lord, my lord, by
After this,
this,
what happened?
we have
After this order, what happened?
exercised, my lord.
Ah,
I have called the officer in charge, my lord. He is on today. He is on leave, my lord. He's not in station today, my lord. This matter might be taken up on 15 so that I can produce the original reports, my lord. The exercise was carried out. My lord, this is a wrong submission on the part of the petitioners that no exercise was carried out. Without filing any RTI, my lord, how can they say that no exercise was carried out, my lord?
no, in that case, if there's no exercise has been carried out, you file a contempt.
Yes,
Not
my
the
lord.
writ
Yes, my lord.
petition.
Lord,
How
sir,
writ petition?
that contempt we will file, that is in the process, but due to paucity of time, it could not be filed. But lordship, since they have already issued LOI, so the tender might be finalized by the respondent authority.
No, it is LOI has been issued.
Yes.
It is finalized.
No,
Yes,
What
agreement has,
happened? What is the status?
agreement has to be carried out thereafter.
My lord, as per this
the
LOI is of
department.
21 June, my lord. And to my knowledge, my lord, agreement was already, my lord, settled between the private respondent and the department, my lord. Let it be on 15, my lord. I will produce a report, my lord. Original report.
Till then, it may be state, lordship.
No, my lord.
Otherwise, the matter will be in practice, lordship. This is very urgent because in WPC,
My lord, their sole contention is that
No,
we have
see,
not
there is
exercised
a
anything.
difficulty.
lordship.
If according to, if it has not been, if the order of this court has been violated, you have to file a contempt.
Lordship.
If it is exercise if exercise has already been undertaken,
Lordship.
if it is
Lordship.
informed to you, has it been informed to you?
Regarding lordship?
The compliance and any exercise by the
No,
authority?
no, lordship. Nothing has been informed.
If it is complied, if it is if the exercise has undertaken already, and it is informed to you, then there will be again separation
Yes, my lord.
of the material facts which will be
Lordship, nothing has been informed to me. No exercise.
At
No.
least they should have filed an RTI, my lord.
Lordship,
But then this is his writ petition.
Yes.
If you have taken, if you have undertaken any exercise, you should inform to him.
Yes,
Rejecting or accepting, whatever
Yes.
may be there.
nothing has been communicated to me.
Agent today he said,
It is why, that is why, my lord, let it be on 15, my lord. I will produce the original
till
report.
then you
Yes,
don't
lordship. Till then, at least.
give effect to this.
My lord,
Yes.
there would be difficulty, my lord.
Otherwise, lordship,
Heard Mr. T. Learned Counsel for the petitioner. Will say status quo. Agent today.
Status quo, my lord.
lordship.
If, my lord, it is found, my lord. We are sure, my lord, exercise has been carried. If it is found,
But
my lord,
nothing
This
has
is
been,
of 21st June.
yes,
nothing has been informed to the petitioner, lordship. Nothing has been, because the petitioner after obtaining
Then
this,
if you are sure, would say if it is not already implemented.
lordship.
Will say if it's not already implemented.
yes, my lord.
If no further process has undertaken.
Yes, my lord.
But lordship, nothing has been.
Learned Counsel for the petition. The had MS
B memo.
in caveat, huh? Had MS B member, Learned Counsel for the caveat is still discharge, huh? In writ petition, heard so and so. T. Taba, learned counsel for the petitioner as well, and also Mr. B. Piche, learned standing counsel for the Rural Development Department and MS.
My lord, may I,
B-
my lord, just respondent number one may be strike out, my lord. Chief Secretary, what is the necessary of Chief Secretary?
We'll see. It's not that. You are not representing Chief Secretary.
Yes, my lord,
Then
because it is in relation to RD department.
it's all right.
Alright.
Chief Secretary is the head of the
My lord, my
executive.
secretary is the, my lord, government, my lord. My secretary RD is the.
Secretary is not
Not made as a
Chief
party.
Secretary.
Yes, my lord.
It's okay. You are not concerned. You are with the Secretary.
Yes, my lord.
MS so learned concept. And also MS B Mena.
Mema.
B Mema for respondent number 8. The on the prayer of learned concept of the parties, respondents, let this matter be listed on 15
Yes.
070 2024. Learned concept for the respondents, huh? Next prayer. Considering that this court had ordered that 24/05/2024 passed in WPC
WPC 51/24.
51 of 2024. You are with the petitioner.
Yes, Lordship.
The writ petition was no, order of this court. What is that? Considering that this court on so and so, passed in WPC 51 of 2024 has directed the respondent authorities to undertake the exercise of approval of the recommendation made by the project director, Kurukume District. Project director within bracket, DRD Kurukume District. In respect of the tender dated 21/08/2024. And according to the petitioner, the respondent authority without undertaking any exercise as directed by this court. The impugned letter of intent has been issued to the respondent number 8.
Yes.
Respondent number 8. Although the respondent, the learned standing counsel for RD strenuously argued that the order of the court has been complied with by undertaking the required exercise as directed.
Required exercise.
Undertake required exercise as directed by this court. Till the next date, the LOI dated 21/06/2024 shall not be given effect to, if not already given effect to.
Lordship, no communication has been made to the petitioner.
We'll consider the learned counsel for the petitioner shall produce the record. Learned standing will shall produce the record.
Lordship, my submission will be
Next
recorded.
day. If
No.
not already given effect to.
Problem.
If it is given effect to, what can be do?
Yes.
Deeply
Please.
obliged.
Yes.
Yes.
My lord,
Why
this
this
application is also filed in,
Huh?
This application is also filed in all provision CRPC.
You filed it today.
Yes.
Is the urgency? Why not move it on? Let us see the provision and see.
Delay has been applied from.
No, we'll just simply fix it because we'll be taking. This is a delay. You have filed a.
No, no delay as of now.
Okay, I is for what? I is for sentence, suspension of sentence.
Yes, sir.
We'll fix it on 15. You in the meantime, you find it out.
The POCSO has,
Yes.
because the new act itself categorically provide that any offences before the coming to the new act, even if you seek for declaring the penalty, then the old act applies, even if you find it today also. If it is offensive for the new.
No, it's okay, but then the provisions which you because the CRPC includes yes. Offense, no issue. So far as the filing, the application and the appeal under the provision under appeal is filed.
Even the provisions is also in terms of the old act, if the offences are before very.
Okay, so if that is, then can we see on the prayer of land concept for the appellate, list this matter on 15. Let us clear ourselves.
Lordship, regarding this lordship, FI lordship, the lordship was inquiry lordship just a few minutes ago lordship. The old fresh FI will be registered against the new criminal law from the first from today lordship. But however the cases which is filed earlier will continue to be tried under the old law till the final disposal.
Earlier.
Lordship.
No, where on, where that is absolutely correct, but then where on
The filing
under
lordship.
which provision of CRPC the application or appeal is to be filed from today?
And
Because
lordship,
it has come into effect from today.
lordship, I think that this bail matters lordship, it can be lordship earlier lordship because the
The offense may be earlier, no
Lordship.
issue. The application, the provision under which
This
the
if
application
provision
is
is
filed.
lordship, if provision is there, then under the provision, the application will be there only lordship.
So that's where, that's the reason we need to see that
Lordship.
CRPC, that there must be Nikki, there must be some provision in the CRPC saving in the thing, repealing clause.
Because in the new POCSO, it is made abundantly clear. Because I myself did two applications.
Well, let us make
Lordship.
ourselves clear.
Otherwise, if nothing is there, then the new provision will apply, but while hearing but the old.
Yes.
provision.
And then since you have filed today, there should not be a problem for, I mean, the limitation.
Yes.
What is the on the prayer of learned counsel for the parties?
Let it be on my
This
lord.
matter on
My lord, can it be on 18th? My lord?
18/07/2020.
All right.
Obliged, lordship.